Steve O'Donnell is probably wishing he could rewind the clock after what he said on the witness stand. NASCAR's president openly admitted that the company viewed SRX as a legitimate competitor and took steps to protect its position. That's the kind of statement that becomes difficult in an antitrust case. Because when you're being accused of having too much control, the last thing you want to do is acknowledge concern about competition. But that is exactly what happened on day 4 of the trial, and the situation became more tense from there. Judge Kenneth Bell eventually stepped in. He paused the proceedings and instructed NASCAR's legal team to move more efficiently. This wasn't a casual suggestion. When a federal judge tells you things are moving too slowly, it often signals concern about unnecessary delays. He also addressed the witnesses directly, giving clear instructions. Answer questions directly, avoid long detours, avoid overly detailed explanations, and provide yes or no answers when possible. In a courtroom, that is the judge setting firm expectations to keep the process focused and fair. This set the tone going forward. The judge watched closely, paying attention to every hesitation, every extended response, and any attempt to complicate simple questions. He made it clear that clarity was essential and that the trial would move forward without unnecessary complications. Shortly after this, Steve O'Donnell took the stand to defend NASCAR's charter system. He explained that charters were worth around $2 million when they launched in 2016 and now sell for more than $40 million, a significant increase in less than a decade. To him, this demonstrated that the system was working well for the teams. On paper, it sounds like strong evidence. If charters have increased so dramatically in value, then teams appear to benefit. But the plaintiffs shifted the discussion toward SRX, Tony Stewart's short-track racing series. It's very small compared to NASCAR's 6 races a year, smaller venues, older cars, and more of an exhibition environment rather than a full competitive league. Under normal circumstances, it wouldn't be a major concern for NASCAR. However, the testimony showed something unexpected. Internal documents indicated that NASCAR did view SRX as competition and discussed the possibility of drivers choosing to race there. With that information, the plaintiffs asked O'Donnell directly whether NASCAR considered SRX competition. He said yes. They then asked whether NASCAR took steps that limited driver participation in SRX. Based on the evidence, he again had to say yes. This created a challenge for NASCAR's broader argument that they are not operating as a monopoly and that teams have many choices. Their internal communications suggested they were concerned about even a relatively small racing series. When a company doesn't believe it has dominant power, it typically doesn't focus heavily on much smaller competitors. The plaintiffs then turned to the charter restrictions themselves. These agreements govern not only NASCAR participation, but also where teams can race, what series drivers can compete in, and what outside opportunities teams are permitted to pursue. O'Donnell defended these rules by explaining that they help maintain NASCAR's brand identity. He argued that if drivers raced in too many unrelated events, it could confuse fans, reduce the value of NASCAR's product, and make sponsorship more difficult. He said the structure protects the sport's consistency and helps the teams in the long run. The plaintiffs offered a different perspective. They argued that these rules are mainly about maintaining control. They said the structure keeps teams deeply committed to NASCAR's system and limits their alternatives. Signing a charter comes with obligations that can be difficult to work around without explicit approval. Cross-examination intensified as attorneys presented examples of teams requesting changes to the charter agreement and being denied. Team owners testified that the process felt like take it or leave it, with limited room for negotiation. O'Donnell disagreed and said teams did have opportunities to provide input, but when pressed for specific examples of changes made directly because of team requests, he was unable to give a clear answer. Then the trial shifted again when Bob Jenkins, the owner of Front Row Motorsports and one of the plaintiffs, took the stand. He spoke about the financial difficulties many teams face, the challenges of generating profit, and the pressure they felt to accept new charter terms. He described NASCAR as having a high level of authority over how the sport operates. NASCAR's attorneys responded by asking an important question. If the charter system is so problematic, why did Jenkins attempt to sell his team to 23XI Racing, another plaintiff in the case? If the structure is flawed, why would another team want to buy into it? And if it is unfair, why would Jenkins try to sell his position within it? Jenkins explained that selling an asset can still make sense, even if the surrounding system has issues. But the question introduced some uncertainty into the discussion. Jurors pay close attention to statements that appear inconsistent, which can affect how testimony is interpreted. The reality is that both sides presented points worth considering. Charters are clearly valuable, often selling for tens of millions of dollars, but that doesn't necessarily mean teams are profitable. Several team owners have said they lose money each year. Denny Hamlin has said 23XI Racing is not yet profitable. Brad Keselowski has spoken openly about financial challenges at RFK Racing. A valuable asset doesn't guarantee a sustainable business model. It's similar to owning a high-value property while struggling to cover ongoing expenses. So Jenkins attempting to sell his team doesn't automatically prove the charter system is fair. In some ways, it may demonstrate how difficult it is for teams to maintain long-term financial stability under the current structure.